This story does not have a happy ending. And because I am not a professional storyteller, I am going to keep it brief. Taylor, though she may look sweet in some pictures, and girls often do. Taylor Schabusiness is a woman from Green Bay, Wisconsin. She was accused of choking her lover during a drug-fueled love affair and dismembering him. She went to trial, and the verdict is in on the trial, and we will watch it at the end of this brief overview. But first, a little backstory. Some things we know: she is a woman. She is from Green Bay, Wisconsin. She claims she is married and has a child born in 2021. Her husband is supposed to be in jail now, and because in the drug world a lot of people go undetected. We don't know a lot about her. She has claimed mental health issues and acted out at times, as seen here in a court video.
You went off on your attorney, Taylor. You went crazy on your attorney.
That may be the first many people heard of Taylor, or that she dismembered her boyfriend in the drug-fueled rage and quote-unquote liked it. The next few details are very graphic. A mother, who I am praying for, found her son's head in her basement and called the cops. Moms, can you imagine? She found it and called the cops at 3 o'clock in the morning and told them that her son was with this Taylor girl, and Taylor was arrested covered in blood. She made up a story about her and a friend picking him up in a van, but she had defense wounds on her arms, cuts and scratches covered in blood. And then while in custody her brother died in July 2022. I do feel for her for that, as that must have been hard, and they say it made her mental state worsen. She went on trial and is saying she is not guilty due to her mental state. And her attorney, who she attacked in the video you saw earlier, defended her. I will say before we watch the other video, as a mother, if anyone leaves a child for a mother to find, that is never and will never be something we as a society will accept. The verdict is in. The trials was live on the crime shows, and other folks covered it, I am sure. I don't do a lot of that, maybe I should. Anyway, here is the final verdict for this girl gone wild.
And my understanding is that the jury has reached a verdict. Is that correct? Yes. Right. If you would hand that to the bailiff then, please. Okay. The first verdict reads as follows. We, the jury, find the defendant, Taylor Denise Schabusiness, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this date, July 26, 2023, signed by the foreperson. The second verdict reads as follows. We, the jury, find the defendant, Taylor Denise Schabusiness, guilty of mutilating a corpse as charged in count 2 of the information, dated this date, July 26, 2023, signed by the foreperson. The next verdict reads, we, the jury, find the defendant, Taylor Denise Schabusiness, guilty of third-degree sexual assault as charged in count 3 of the information, dated this date, 26th day of July, 2023, signed by the foreperson. The verdicts appear to be in order. Do either of the parties request that I poll the jury? Mr. Saunders?
No.
Mr. Freilich?
Yes.
Okay. Ladies and gentlemen, I'm going to do what's called polling the jury. It's a very simple process. So all I'm going to do is go down the line and ask each of you if this is your verdict. Your answer is either yes or no. I'm going to start in the back corner, ma'am. Are these your verdicts? Yes. Ma'am, are these your verdicts?
Yes.
Ma'am, are these your verdicts?
Yes.
Ma'am, are these your verdicts?
Yes.
Ma'am, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts?
Yes.
In the front to the right, ma'am, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts? Okay, the jury has now been polled. Ladies and gentlemen of the jury, for today, your tasks are concluded. We're going to start tomorrow morning on the second phase, at which point in the beginning I will give you some further instructions, and then we will get underway on that phase. The attorneys and I have a few things that we're going to need to take up before that phase starts, so I'm going to ask that you be in the jury room by 9:15. I want to start right at 9:15, and we will hopefully get our matters resolved ahead of that time. But for today, your service is concluded. I am going to, again, read you that instruction that I've done every day since you've started. Please do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device with communication capabilities to share any information about this case. For example, do not communicate by blog, email, text message, Twitter, or in any other way on or off the computer. Do not permit anyone to communicate with you, and if anyone does so despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based upon the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. We are done for today. Have a good evening. We will see you tomorrow morning at 8:15 or 9:15 sharp. All rise for the jury. Be seated. Is the matter regarding Dr. O'Donnell still a contested issue? I'm seeing nods from the state.
As of last night, yes.
Okay. So here's how we're going to handle this. I've indicated to the jury that I want them to report at 9:15. Mr. Freilich, it's entirely up to you if you want to bring Dr. O'Donnell here tomorrow morning at 8:15 for me to hear from. But I'm going to indicate to you the parameters of where that situation is. I've reviewed your memorandum, which is all I can really work with, because this is what you've essentially said to me. This is what he's going to testify about. The first opinion is that Mr. Business was acutely intoxicated and impaired by acute methamphetamine use at the time of the alleged asphyxiation. The problem I'm having with that assertion is I'm not sure it's relevant given the status of the intoxication defense. So I'm not sure that having it here is going to assist you in that, but and I need you to understand where I am regarding that topic before you decide that's what you want to bring it here for. The next point is that the long-term and excessive use of methamphetamine has chronic brain damage consequences. The problem with that situation is I don't know that he is competent to diagnose chronic brain damage. So while he could assert that long-term excessive use of methamphetamine has chronic brain damage consequences, I don't think he's going to be qualified to testify that as a professional, I can say to a reasonable degree of certainty used in my profession that Mr. Business has chronic brain damage. Frankly, I think the only opinion that's been asserted regarding her mental health condition as far as a diagnosis is bipolar, and that was done at Nicolet, and there's some dispute about whether that was an accurate diagnosis, but I don't know that one would qualify bipolar as being a chronic brain damage. So I'm concerned that if he's going to come in and start opining about that the connection won't be made. And then, of course, even if he is able to say that she does have chronic brain damage, the next step he has to take is that somehow that impacted responsibility. And I think there's a concern there as well. But I'm putting you on notice of that view that I'm starting to develop regarding the submissions you've made to me. The second bullet point is that long-term adolescent use of marijuana arrests brain development. Again, I'm not familiar with the diagnosis that any qualified psychologist or other professional qualified to make such a diagnosis has actually made in this case. I don't know that one equates brain development with bipolar. I've never heard that, but I'm not an expert. So the notion that he can opine that someone who uses marijuana as an adolescent might have brain damage, I'm not sure is going to be useful to this jury, because we don't know if your client has that. And the next step is, how does that affect responsibility? And I'm not sure he's qualified to give that opinion either. The next bullet point is, Ms. Shabiznes was not treated with psychotropic drugs to control or mitigate her psychiatric illnesses. He certainly, and again I want to say, I'm satisfied that he's qualified as a pharmacologist. I'm not questioning his qualifications as that. He certainly reviewed his CV and listened to his testimony at the prior hearing, and he's a qualified pharmacologist for sure. But as far as psychiatric illnesses, again, the only thing that I've heard about from the testimony in the records is a bipolar diagnosis at Nicolet, which these other psychologists have repeated. So that the only thing that one could conclude from this assertion is that she was not treated with psychotropic drugs to control or mitigate her bipolar disorder. And then the question is, how does that impact responsibility? Many people have bipolar, so the next question you have is does someone who has bipolar, will the consequences be that you're unable to appreciate the responsibility in a criminal case? That's another concern I have with whether he's going to be qualified to even testify about that. The next point is psychotropic drugs do have efficacy in a large percentage of patients who take them. Well, I'm satisfied he'd be competent to testify about that.
They continue on talking, and she looks unimpressed. I hope you learned something about this case, and that if you're interested in learning more, there are a lot of clips on sites, and Law and Crime covered the trial, so you can literally watch it all unfold. Thanks for watching. I know this is something a little different, but it is a unique case and is the case of a girl gone wild.